break that one up?
Yeah, the third page should be.
Okay. That's what we don't want to
They're all the same.
I just want to clarify in time. I know the court has given us an hour and a half each. And, I have here that the state has, I've asked James to clarify, the state has 27 remaining, is that correct?
I gave him 30 minutes because I gave him 2 minutes in an interruption to have the class go out.
Fair enough. I just want to make sure we're on the same page on that.
But I didn't bring my hook upstairs with me, so.
And just how late do we plan on staying tonight?
All depends on when we get them in here to finish and get it to them. I'd like them to at least try and deliberate for an hour or more. Let's say listen to all of this for the last week and a half. And then I'm going to kind of partly leave it up to them. I've had them when I've been out for an hour or two say, all right, why don't we come back tomorrow? And I say, no, if you give us a few more minutes, we'll be ready to go. And if I get that kind of response from them, then I'll give them a little more leeway. But I'd like to think that we'll be out of here sometime between 6 and 7, or I'll cut them off sometime between 6 and 7. They don't like us keeping jury too late.
Are you going to let them know when they go back so they don't feel like this guy's going to keep it serious? Well, no, I'm going to send you back for an hour or two, then we'll break for the day.
No, I'll tell them.
All right, thanks.
All right, jury, please. President Canada for judgment.
All right, receive it, please. You may proceed with rebuttal argument.
Thank you, Judge Kennedy, for your support, counsel. Good evening, ladies and gentlemen. Let's kind of start off with something the defense attorney was talking about towards the tail end of his discussion with you. You may recall he just stood up here and said to you that, whether the defendant was at the Hertz rental car is a hotly contested issue. There's no evidence of that here. Weren't you all sitting in the courtroom yesterday when the defendant admitted going to the Hertz rental car? So, his attorney can come up and say anything within reason. What he says is not evidence. You rely on the evidence, and he's the one who said all the other things to you. The same person who made that statement that you heard for the last hour before you took your break. He said, for example, he suggested some people may treat you as not being intelligent, and then he said, well, why didn't they take gunshot residue from the defendant, 4 or 5 days after he shot the victim, when he showered who knows how many times? Then he talked about President Kennedy a little bit. I can't help but to think back about the defendant's letter that he calls a dopey letter, but admits as damning evidence of guilt, in which the defendant is saying to himself, it's up to my lawyer to confuse...
Overruled.
I'm just talking about what the defendant said in his letter that he calls a dopey letter, because what else can one say? I mean, it is damning evidence of guilt. It's not just what he says when you read the lines. You've got to read between the lines, ladies and gentlemen. And at all times, instead of thinking about these side things like Kennedy or gunshot residue from someone a week later, keep your eye on the ball. Keep your eye on the big picture. Because when you consider everything together, which is what you're supposed to do, there's nothing else to conclude but that the defendant is guilty in this case. So in this letter, already have an alibi. Something's going to happen to Ariel. Don't fuck with your people, or you'll fuck with hers. Tim may turn state's evidence first. He's worried about what Tim has to say about him because Tim would know, and he knows what he did. What's the next thing that happened? He starts talking about the police, like the police are on trial. There you go. The police are on trial. The police didn't do anything except professionally investigate what he did which is he shot Sean Taylor and he lay there and bled to death while the defendant drove off. You know, you're going to hear an instruction from the judge. The defense lawyer told you about some. Let me tell you about a couple of others. There are no other laws that apply to this case. Even if you don't like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. You're not going to hear any law given to you that the police have to do anything that they didn't say that they did. There's no law that says they have to tape record everything. There's no law that says they did anything wrong. They're not investigating an overdue book. They are investigating a murder. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. So, what does he say at the very end? Well, I don't want you to feel sorry for my client or his family while he's showing you pictures of them. So think about that. The voluntariness of the statement. Well, ladies and gentlemen, a picture is worth 1,000 words. What better evidence can there be than the defendant saying it's completely free and voluntary? I mean, there's his initial confession. You saw him earlier saying it on videotape. Free, voluntary, true, and correct. And not only did he say it then, no matter how counsel may try to explain it, he said it in court. He said it on the second floor of this building next to an American flag. You know, the defense lawyer's invoking the Constitution. When he swore to tell the truth with his lawyer in the courtroom and the judge on the bench and his father 20, 50 feet away. He got on a witness stand, contrary to what he said yesterday, and he swore to God again that that statement is true and correct. The statement in which he said he shot Sean Taylor and that it was free and voluntary. So the defense lawyer wants you to think, well, he didn't think it was relevant. Well, what's not relevant? Is telling the truth not relevant when you're on the witness stand? You want to know that then he said, or there was some suggestion at some point that he didn't want to cooperate against Charles Wardlow. What does that have to do with anything? You want to know what really happened, ladies and gentlemen? He may have thought that he'd be asked some questions and not others, but I asked him the obvious question. You swore it was true. You swore it was free and voluntary. Was it or wasn't it? And he said yes. Under oath in court on June the 9th of 2011. So when you're considering whether the statement is free and voluntary, besides the fact the police did nothing wrong, besides the fact that they gave him his Miranda rights that he's entitled to, he swore over and over again that it was free and voluntary. I had my Miranda rights. And then yesterday, he's desperate. He admitted to you in the very beginning of cross-examination, he has lied to protect himself. He has sent letters to protect himself. He tried to create a false alibi to protect himself. He has lied under oath to protect himself. He changed his story about the phone when he saw the cell records and he knew he couldn't deny having the phone at night. He changed his story about the food and when he was fed, when he saw the video and he saw the food in front of him. The fact that there's still pizza there doesn't mean he didn't get pizza or eat pizza earlier, and it really doesn't matter because they gave it to him at the end of the day. He changed his story about Officer Walsh. He changes his story over and over again for the same reason he wrote that letter, to try to subvert justice, and that's why the defense lawyer can't explain it. Let's talk about some other things and talk about common sense. The defendant is there at 2:15 or 12 o'clock, and he's signing this sketch and these shoes at 2:15. At 2:15, let me come back to that in a second. Firstly, Mr. Mancini did not positively identify those shoes as the shoes that kicked the door in. He said those shoes look very similar to the Nike shop pattern on the box and the box cover. He could not exclude that from kicking the door in. It has the same herringbone print. He is an expert. It's a quick motion to kick a door in, and I submit to you that the person who would best know who kicked the door in is the person who was there, and he was there. But regardless, and one of the reasons the principal instruction is important, the Nike shocks was worn by somebody who burglarized the home. You've seen the box cover, you've seen the print. There can be no reasonable question about that. So the story that he stayed in the car is another lie. Now let's talk about the shoes, Mark. The defense lawyer says to you that the police were so eager to make an arrest, so eager to pin it on them, they had to do it. They had to do it. 4 days had gone by, and they were nowhere. Nowhere. They had information from Sasha about Charles and Jason Mitchell. Within a couple of days, they had a tip that named him and some of his co-defendants, and they had a ping for Mitchell and Wardlow off of Sean Taylor's cell tower, and Wardlow was winds up found in a car with him. So they weren't nowhere. 4 months hadn't gone by, and then why would they pin something on somebody that didn't do it 4 days after the crime, most particularly? They hadn't even met Tim Brown yet, and that's what's important about those shoes. Why would they get him to say he was wearing those shoes to try to get him to say, I kicked the door in and shot Sean Taylor, when later that day, Tim Brown or Benja Hunt could have walked in wearing them? That's why it doesn't make any sense. Why did they need him to say he shot Sean Taylor at 2 o'clock in the afternoon before Wardlow was even talking? Sean Taylor is shot. The person who shot him is one of the people who's responsible. There are 4 other people responsible. He's only shot once. So anyone who drove, who pried the door, who helped, who planned to get money, all those people are equally responsible. Why in the world would they want Eric Rivera to say that he did all of these things before they've talked to 2/3 or 2/5 of the people? It doesn't make any sense. Think about it. Let's talk about the defendant saying he's merely present at the scene. But you've seen the totality of the evidence. This is not a scenario in which he's going from his girlfriend's house to a 7-Eleven. And they say, well, wait a second, I'll be right out. And somebody goes in and commits a robbery and comes out and he doesn't know nothing about it and never did anything. This is something they discussed on the way there. He brought a gun. He's the only one who brought a gun. Why would they try to lock him in to saying that he's the only one who brought a gun? How would that help the police? Let's look at page 26. They haven't even talked to some of the people. They don't know who brought a gun or who didn't. Did anyone else have a weapon besides you? No. Did you intend to kill Sean Taylor? Why would they get him to say that if they're trying to take advantage of him? He told them what happened. They took a statement from him on tape later and had him repeat exactly what he told them about how he killed Sean Taylor. You know what else is kind of interesting about this statement? They're still getting information from him. When they asked him what door did he go in the back, was it a bedroom or a bathroom, he says the back door that leads to the house. He corrects the detective about that. This is all information that comes from his own memory. And don't forget, his performance yesterday was 6 years in the making. He's had a long time to think about what he has to say and how he has to say it to try to do what he tried to accomplish in that letter. Now, you'll notice in the videotape that's 35 minutes, when someone says, well, how many weapons were brought, he doesn't say, how many weapons were brought? When they go, did you go in the back door? He doesn't say, did you go in the back door? In other words, he's not repeating the question all the time, so he can think about it a little bit more. He can't change himself. You saw what he's like when he's answering questions and he's telling the truth. When he's sitting up there, he's always thinking, what do I have to say? What would these people like to hear? What would be persuasive to them? Sloppy investigation. Well, or insufficient or incomplete investigation. Well, let's see. So, evidently there's somebody talking to Jason Mitchell on the phone, who maybe is yet unidentified. What does that have to do with the fact that within 4 days, They identified every person in the house committing the armed burglary. They corroborated the tip. They had a confession from that man, the man who shot Sean Taylor. The defendant in the car, he's associated with that car. He was at the rental. His address is right there. You'll see it on another photograph, 804 Zana Drive. Probably an address they put in to get back from Miami to Fort Myers. Just another thing in the totality of the circumstances of the evidence against him. And the confession that he told you on the videotape, that he admitted to in court, that he admitted in that statement, that he reviewed and signed an initial, in and of itself is proof beyond any doubt that he is guilty of first-degree murder. In combination with everything, particularly the letter, which in and of itself, in combination with everything else, is proof beyond a reasonable doubt, is an overwhelming case against this defendant. Another thing the defense suggests, do you really believe that they're among the law enforcement agencies to come in and lie about the defendant? I mean, are they interested in what's happening in the trial? Another thing the defense suggests, do you really believe that they're among the law enforcement agencies to come in and lie about? On the witness stand than just doing everything. It's always him, it's always them, it's always somebody else. It's never responsibility. You know what? You should take responsibility for the decisions that you make in life. He made decisions. He made decisions the night he shot Sean Taylor. He made decisions the night he went there. He made decisions the night he bought a gun, and that's why that man is dead. He made decisions the day he waived the Miranda rights that he knew. He made decisions about talking to the police. He made decisions about going on tape. Those were all his decisions. And he made a decision when he admitted in court that it was all true. And that is uncontested. They may try to talk about the whys and the wheres and all these other things, but that is uncontested. That's a fact. Maybe when the defendant's father was looking for him and people said that he wasn't arrested, do you know why? He wasn't arrested. Just as Detective Segovia and just as Detective Bellew told you. I talked with you a couple of times earlier about demeanor. And you had an opportunity to see those two detectives who didn't sugarcoat anything to you. They followed the law, but they wanted to talk to him. I mean, there's no question about that. They wanted to keep him talking. He denies that Detective Bellew made that statement to him about Sean Taylor and asking him to nod his head. And you ask yourselves, who do you believe? particularly in light of the big picture, particularly in light of the letter, particularly in light of the videotaped confession. I mean, you know, you all said in voir dire and jury selection that, okay, I understand whether a parent's there or not is only one factor. Of course, this kid winds up being 17 years and 8 months, 5 months shy of the day he wrote that letter. He knew a lot then. You all said in jury selection, doesn't have to be taped. The law turns out nothing has to be taped. The police followed the law. And it turns out, ladies and gentlemen, although I couldn't discuss it in voir dire, that not only is he 17 years and 8 months old, there is a videotape confession. A videotape. I mean, Miranda forms, not speculation, but things that you can touch, things that you can feel. And so, in many respects, I say to you, ladies and gentlemen, do you believe innuendo, or speculation, or imagination, or someone who's lying all the time, or do you believe your own eyes and ears? You saw it. You heard it. The Miranda, the diagram, the sketch, you can pick it up, you can feel it. Looking at that picture, you can feel it. You can see that there's overwhelming proof of guilt. This discussion of Romaine, who said the defendant wasn't there, he said he was there, and she said he was there 2 weeks after it happened. And Alexia, I mean, what does she have to lie about? I mean, what does she get out of all of this? Although, at the end of the day, ladies and gentlemen, whether he drove the car off or not,